as well as the so-called non-adjournment decision. So all the 5 issues fall under what I'm discussing now. Right. So, and in that, I will be referring briefly to the events of the following dates: the 13th of September, the 27th of October, the 28th of October, and the 1st and 2nd of November. So it's the 13th September, 27th and 28th October, and then 1 and 2 November. So that covers quite a bit of our case. Now, in this behavior that repeated itself over that period of time, both in respect of the failure to postpone, or refusal to postpone rather, as well as the denial of legal representation. Those are the big topics under this. So let me start with the refusal to postpone. Of course, as one of the justices pointed out, these things were, I think, the presiding judge. They manifested themselves interchangeably. So in other words, the refusal to postpone is also related to the carrying on in the absence of either the public protector or the lawyers. So, but I'll differentiate them. Now, what then happened on the? I won't go back to the events of the 13th. I've already described blow by blow what happened that day leading up to the 4 o'clock surprise. Let's call it change of heart. I think somebody must have advised the chairperson sometime at 4 o'clock that he messed up. And then we just got this email that says, "Oh, now you got your postponement, Nero Motu or Suo Motu, whichever it is the correct Latin term, sometime in the afternoon." But by then the damage was done. That's the point. Why was the damage done? Because he had already allowed the continuation of the proceedings in the absence of both the public protector and the legal representative. What is more, which is very important, and I want to isolate this because it goes to the heart of what we call irrationality. What is more, my ladies, is that by ruling that the members could continue questioning the witness, forget for now that the fact that it was done in the absence of legal representatives and in the absence of the public protector. But it was in breach of the directive that my learned friend Ms. Mdntv referred you to, which was at page 128, and Justice Klute found it somewhere else.
The questioning of the Dyantyi, the witness, before you had a chance to prosecute.
Correct. That's the point. So I won't belabor that point. In other words, yes, Justice Ali, you got it 100% right. So on top of everything else, the absence of lawyers, the absence of the public protector, was also done out of sequence of the...
Is the issue that it was done out of sequence? Because the thing is, they say, well, he had the discretion to do that.
Well, that's exactly the point. In law, in our law at least, not now as well, the whole notion of the principle of legality is articulated in those cases like federal and pharmaceutical and so on. Is that if you are a public official, you cannot exercise a power that you don't have. It's a manifestation of the old ultra vires rule. In other words, if they say that he had a discretion to subvert,
It says that the
well, then I'd like to know where he gets that discretion. question.
But is the issue not that whatever then transpired in your and public protector's absence on the 30th, although you had indicated you were not ready to cross-examine, is the issue not then that those proceedings, or the continuation of those proceedings, the public protector or the applicant in a disadvantageous position because if there was a need to object to any question or a need to take either some point or others, you would have been deprived of the opportunity to examine. Is that the issue? Or is the issue now here out of sequence? What is the consequence?
Oh. Yes, no. I'm sorry, Justice Ali. Unfortunately, that question conflicts two separate issues. Yes, the issue of the absence of the public protector herself and the absence of the legal representative speaks to what you're saying. We all know that's why proceedings must always be
to object.
Yes. Yes, that's why in rule. Okay, let me make an example. Section 35(3) of the Constitution, of our Constitution, one of the things it guarantees is that in at least in the context of criminal proceedings, those proceedings not proceed in the absence of the accused. But the underlying principle is what you are articulating, Justice Ali. The underlying principle to that rule in Section 55(3), I think it's D or one of those, of the okay, 3C for starters says to have a public trial before an ordinary court, and that's to do with the presence, but there's one that speaks specifically about the presence of the accused. Okay, it's derived from 35(3)(c). It's section. It's the section of the Criminal Procedure Act, I'll come to it, which derives from this. I think it's not 168. 168 deals with postponements. It's probably 158. Yes, section 158 of the Criminal Procedure Act says that all, I'm paraphrasing, all criminal proceedings should take place in the presence of the accused. And we then know the exceptions, if the person is rowdy or whatever, or if the person is in the prison, or there's a video link or whatever. The general rule is it's a constitutionally entrenched right, the presence of the person. But underlying that principle is exactly what you're saying. How can you be tried in your absence? Because you won't have a chance to object, you won't have a chance to even say to your lawyer, well, let alone if the lawyers are kicked out. Even if the lawyers were there, if the person is not there to say, listen, that's not how it happened, Mr. Jana is making a mistake, object to this, object to that. That's the underlying principle. So, yes, so that's the one thing, that's the absence. But the issue of the sequence is a different complaint, and it deals with the following, that the chairperson, unless it were going to be told where he gets that, does not have the power. He cannot exercise the power he doesn't have. He doesn't have the power to change the sequence of questioning, because the rule.
Just on that, just on that.
Yes,
Just understanding correctly,
Mm-hmm.
talking about the Oliveira's submission.
Absolutely.
The definition section of the directives.
Yes.
It's also called directives.
correction.
Yeah, let's call them that. Yeah.
On 1.3 under the definitions.
1.3.
This directive governing the appearance of persons appearing before the committee, the purpose of the following hearings, as set out here in I'm giving the summarized version, and then seen from what you were submitting that you possibly were referring to. I'm sorry, my extract that I've taken, I think, has got different numbering to yours, but it appeared to me that you might be referring to 6.7 to 6.9.
Absolutely. 100%.
That's
That's exactly where I was going. Yeah. You've cut away 5 minutes of the journey I was going to take. Yes. 6.7, let's jump straight there. You'll find it at page 375. Yes, which is your version of the directives, volume 4, Madam Justice Cruiser. 375, right. So it says then, the evidence leaders may, in the presence of the evidence, ask any questions, including leading questions of any witness. So far, so good. So that was done on that fateful Saturday I was talking about. After the evidence leaders have presented the evidence, the public protector may cross-examine the witness. So that is not done. And they say thereafter, that's very important. Thereafter, members of the committee shall, subject to the directives below, indicate the chairperson whether they wish to pose any questions. And so on. In other words, the sequence was subverted, and there must be a reason why we all know. Imagine if we got into a case and then someone says, well, today we're just going to start with a examination, and then tomorrow we'll do the examination in chief, and then I'll start with the re-examination. You can't do that unless if you're the
Whatever discretion the director is based in the chairperson, does not include discretion to change the order of question. Because 6.10 talks about the manner in which and the duration of time spent
by the members.
Yes, and 6.9 is by the members. The members of shall ask to be subject to the directive and intend to whether they wish to pose any questions to them.
Absolutely.
So you're saying there's no provision for a calling for a questioning of a witness out of chronology?
There isn't. And this ultra virus for that reason alone.
What is the position with regard to objection? Do they say you're allowed to object?
Yes, no, we are. We're allowed to object in the normal way, Justice Ali. If somebody asks a question that you're not happy with and whatever, both sides have the right to object.
Sorry, Mr. Crawford, just on that, maybe you can assist me. Is one in these proceedings permitted to object to a question by a member?
Yes. Yes. In fact, I'm just trying to.
In terms of the direct.
Yes, I'm trying to scratch my memory. yes. So one is. In fact, many I have done so myself. Well, it's embedded in the power of legal representation. You can't have full legal representation. Yes, no. It doesn't say you may object. Just like in court, there's nowhere where it says in the rules.
Yeah, the reason why I asked this question is obvious because everybody's been saying that the proceedings are sui generis.
Yes.
It's not exactly court proceedings. It's not exactly impartial tribunal.
Yeah.
And other politicians.
No. Okay, well, let me address this politician story because that's actually another misnomer. There's no. Well, firstly, let me start with your point, Justice Ali, about objections. It's important in the sense that the absence of the lawyers and the public protector obviously deprives you a chance to object, the point you made earlier. So let's park that.
But you didn't raise your question.
Ooh, I raised it 100 times. It's let me
That is the basis. After all the
there. It's, I can find it. It's ground number. Well, we refer to the word thereafter specifically. My learned friend will find it.
Yes, no, but there's a word thereafter.
Yeah, that's about the sequence.
To the order. For you
It's
calling
this.
for women now in question after order.
Yes, but thereafter means exactly that, Justice.
But if you don't, you explain the prejudice that she suffered, being that she was unable to object immediately when you raise that in
Okay. Here we go again. That is a conflation of the two issues. The first issue is the absence, right? So if you're absent, then you cannot object. So let's get that out of the way. Because you are not there and your lawyers are not there, then you are deprived of the chance to object. That is why there's a Rule 35(3) and Section 158 of the Criminal Procedure Act. That's the analogy I made. Let's put that aside, that you've been deprived of the chance to object. I'm now saying, in addition to that, and separately, as a separate ground, the chairperson has transgressed the rule of law, the principle of legality, by subverting the sequence without any authority to do so. That's a separate complaint. Because if we
exceeded his powers in doing it.
pardon?
That's what you say, he exceeded his powers.
So,
The question was he exceeded his power.
oh yes, absolutely. Yes. Yeah, without authority. Yes. Now, and Fed Life, pharmaceutical, all those, okay. You see the difference between public officials and private individuals like me and my little friend is that I can wake up and sell my house. Nobody's going to say, but you bought it last week, and do whatever I want to do. But if I'm a public official, I cannot, that's the rule 1 of the rule of law. I cannot do anything, literally anything, unless I'm empowered to do so. And some people even don't understand it. They say, no, but there's no prohibition. But no, it doesn't work like that. The prohibition is irrelevant. You must have a specific power, what's called an empowering provision, which allows you to do. Otherwise, there'll be chaos. There's all sorts of.
Yes, we get the point of the principle of legality.
Right. Now, where I was then is that, yeah, so that there are those breaches. Then I say that in aggravation of this, on the 27th, this is now, we're now moving to the next date. 27 October, that's correct. What then happens is that there is the application, which is brought, the so-called adjournment application, in which we say, to paraphrase, due to the events of the 13th, we are now going to bring a review application, and therefore we're asking you, committee, to postpone the proceedings pending that litigation, right? And then that application is dismissed on the spot. What is the problem with that? There are two problems. One is we gave them quotation from the Piccoli case, which you will find at page 542 of the authorities manual. Volume 1. This is a quotation from that other work, one of the key works in South African administrative law, which was getting judicial endorsement in the Piccoli case. And I'm reading.
The Piccoli case starts on 5 and you say?
I'm saying 542, my lady.
542.
Yes, 542 is the end of the third paragraph.
motion still treated as valid, that one.
Yes, that's the one, yeah. And then it says, for that reason, the law requires of all concerned to respect the pending legal process and, as far as is reasonably possible, to limit the practical consequences of the challenged action. And then here's the quote. It says, in appropriate circumstances, an authority should halt its actions when it is aware that review proceedings are to be instituted, not even instituted yet, that are to be instituted against it. Failure to do so may render the official concerned liable for contempt of court. Now,
I'm so sorry, but I can't find.
oh, I'm so sorry, madam.
You could just
542.
yeah, 1542.
Yes, the first paragraph starts with for the president.
Yes.
But then in order,
Yes.
the one I'm reading is the protect exercise.
Oh, okay.
Yes, and it's towards the end, my lady. Towards the end of that, it starts for that reason. That sentence. Yes. Yes. And the quotation is the last two words. Now, why do we have that? We have that because it is normally, it's, you might even call it a rule of common sense or trying to save public money. In other words, there might be a long drawn process that's going to take years and years. But in certain circumstances, if you say, look, let's just stop here, I'm going to court, in appropriate circumstances, that requires for you to stop. Now, the committee, and I'm not putting this higher than saying that they had a gun, they had to stop or whatever. But what we're saying is that, remember, in review proceedings, we're really looking at the rationality of the decision. So, having put up, even if I say so myself, a very comprehensive application, quoting Pinochet, quoting the Passon case, quoting Sarfu, and so on, and explaining why it is that the proceedings should be adjourned, the committee failed to do so. But here's the punchline. And this, quite frankly, should be the beginning and the end of this case. In doing so, on the 27th, you will see that this was foreshadowed in the correspondence. He even says, the chairperson, well, if we fight against you, this and this and this will happen. So we said, but how do you know that you're going to fight again? This is the typical predetermined outcome. But just by the luck of the Lord, because it's always difficult to prove this predetermined outcome story. You have to infer it. Here, we have the smoking gun. The chairperson, my ladies, took out a piece of paper and read it as the outcome. So where was this piece of paper written? By who? So it was literally going through the motions. Listened to us, had so-called deliberations, and then drew a piece of paper and read from it. Now, where in the world can you have that situation if it's not a predetermined outcome? What is worse is that we make this allegation in the founding affidavit, my ladies. Expecting that some in the answering affidavit, someone is going to say, are you out of your mind? What piece of paper are you talking about? It's not denied. What is more is that the piece of paper, having it not denied by the chairperson, is not discovered, which, well, for lack of a better word, is sacrilege. Because the predetermined outcome, it even makes it more egregious than just being a predetermined outcome. It also means it might have come from someone. Maybe it's in somebody else's handwriting. I don't know, I'm just speculating. It doesn't matter, yes. The point of the matter is that There's a predetermined outcome, as I say. For the first time, at least since I've done cases like this, we have the smoking gun of somebody reading from a predetermined outcome. So that's the 27th. Right. So, okay. Let's say he then denies us, predetermined or otherwise, denies the postponement. We then say, well, we cannot, therefore, the legal team, at least, is not in a position to continue because our mandate, which was basically communicated to him in writing to the chairperson, Justices writing, our mandate for today, the 27th of October, is merely to move this postponement. This is what gets exaggerated and blown out of proportion as a walkout, you call it what you will, withdrawal, this, that, and the other. Don't worry about the hyperbole. The point of the matter is that the legal team indicates that our mandate, and we are creatures of instructions, our mandate.
So in effect, what you say is the public protector instructed the legal team only to move an adjournment on that day and did not consider that in the event that she was unsuccessful in adjournment in the matter may continue.
No, I don't know what you're not in her head. I'm saying the instruction.
She didn't provide for the eventuality
yes.
of an adjournment being refused.
Yes. I don't know. I mean, I can't speak for the public protector. I'm just talking for the legal team. I'm saying the legal team was under instructions to, and this was communicated in a letter dated 21 October to the chairperson. You say, when we come on the 27th, in fairness to him, when we come on the 27th, our mandate is merely to move for the postponement.
So, Mr. Glick,
21. 21 October. This is common cause. Right. Now, come the day, then it transpires like that. The legal team withdraws from those proceedings of that day and explains that the mandate ends here. And there's case law on the. One can criticize the legal team if they want or whatever, but that's not what we're here for. We're here for the public protector. So that's the 27th. Okay. Then the proceedings close. Rather, the public protector is now left on her own devices because she reports to Parliament. So she could, unlike me, she can't very well say, well, I'm living with my legal team. So she stays. Then she's quizzed and so on. It doesn't matter. She sends a letter. She sends a letter that evening to the chairperson or secretariat to say, because the chairperson said we're continuing tomorrow with or without a legal team. She says, am I expected to attend on the following day? The reply comes, it says, yes, you must come. So she comes on the 28th.
When you say she was quizzed about whether she terminated your mandate.
Yeah, she was quizzed about the whole thing about the mandate and
the answer was that she did not terminate your mandate.
No. The answer is in writing. We'll get to that. You'll get the answer in the letter she wrote on the 28th. When she arrives on the 28th, she then says to them, look, my legal team is not here. I need to speak to them. I need to ascertain whether they're coming back or what have you. And she says, please, person, give me 7 days No, I'm sorry. Before you make that note, just give me until the 7th. I don't know how many days that was. Give me until the 7th, which was
3 and 7 will be roughly about 9 days.
something like that. But give me until the 7th, which is a Monday a week. This was now Friday the 28th. Give me Monday a week to sort this whole thing out, and I'll come back. If my legal team had withdrawn forever, then I'll come and tell you that I need a new legal team. Yes, you'll find that letter at 341. Thank you. No, okay, no, we're not there yet. Just leave it open because we're going to get to it now. But she says, can I have a postponement until the 7th?
On the 31st,
No, on the 28th. We're still on the 28th. The Friday, the 28th. I said, don't forget about 341 for now. We'll come to it now.
and 341 not there.
No, that's the 31st. On the 28th, Justice Ali, she says, I'd like to be given a week to sort out.
So she verbally asked.
Yes, she does. It's in the record. Yes. Then that's denied. The chairperson says, no, I'm not giving you those days. You must come back on the 1st. Which is, that's where we say she's literally given 1 working day despite the explanation. And then on the 31st, this is what she then writes. At 341 now. I refer to the ruling made by the chairperson on Friday, 28/22, that I must report back to him regarding my efforts to secure and/or confirm the position of my legal representative in respect of the proceedings which were on that day rescheduled to take place on the 1st of 2022 and going forward to the end of the inquiry. It has understandably been extremely difficult to hold any meaningful consultations as some of the legal representatives were unavailable or traveling outside of the Gauteng province, whatever. The purpose of this letter, which I request you to kindly refer to the chairperson, is to confirm that I will be meaning my public prospect, will be physically attending the committee sitting scheduled for tomorrow, that's the 1st, and more fully present to the committee the status quo as at that point. Hopefully by then even more progress will have been made. Either way, it is my intention to place on record whatever the actual situation will be, so that the committee may take whatever decision it deems appropriate and reasonable in the circumstances. The next letter is quite long, so I'm not going to read it. That's at 342. This is then what she presents at the meeting of the 1st. She says, the attorneys, although I have not, okay, let me read some of it. As repeatedly stated by me to the committee, it was never the case that any of my legal representative quote withdrew from representing me or walked out as incorrectly alleged by some members of the committee. The legal practitioners merely implemented, and that's the question you were asking, Justin, in the most appropriate manner available in their opinion within the circumstances, the mandate which they had at that stage, which was only to deal with the postponement application without giving any recognition to the committee as presently constituted until otherwise advised. And I will show that this is not an unusual occurrence. There's a case, again, thank the Lord. Literally a day after we finalized our heads of argument, there's a case that was published, which was from the SCA. It's a case of Dyantyi. It's just a coincidence that the same name of the chairperson. Case of Dyantyi versus Rhodes. It's in volume 1, page 143. of the authorities panel. You'll find that case, it's uncanny that the Supreme Court of Appeal had to deal with such a situation as we had to deal with. This is a judgment of Van der Merwe J.A., Salduka J.A., Nichols J.A., Hughes J.A., and Matrojana J.A. concurring. You'll find it at 143. So, yes, it was. But the point is bias and legal representation. So, they say that Ms. DeFoss said that there was no intention to delay the matter. She explained that both she and Mr. Mahamel and whatever, these are the lawyers, had prior commitments for these dates. Ms. DeFoss was engaged in an application in Gauteng local division to restrain the deportation of a person who faced the death penalty in Botswana. Mr. Mahamel was engaged in a matter between the President of the Republic of South Africa and the Public Protector. I'm sorry, paragraph 12, my lady, on page 145. Yes. So this lawyer was involved in this other one in that year, which had many weeks before been set down for 23rd to 27th October 2017. At no stage were these amendments disputed. So let's pause there. Similarly, the public protector said to the committee, my lawyers are involved. In fact, what actually had happened is that there were directives that came from the Constitutional Court on the 28th, which said that, the usual directives, you must reply by such and such a date and what have you. And the DA had just served us on the 28th as well with a 2,000-page record in that Concord matter. So exactly similar issues about unavailability, no dispute. Then I'll jump to paragraph 14. Ms. DeFoss concluded by contending that to set the matter down for days on which counsel for Ms. Dyantyi were unavailable would, in these circumstances, constitute gross irregularity. Despite similar protestation by Mr. Powers, the protocol simply ruled, Mr. Mileham, I think I must do the dates now. All right, 26, 27, 6, 7, 8 November. Thank you. You can back up. That's exactly what happened to us. So they said, well, I hear all this about your constitutional court or whatever. You must be here on the 1st and 2nd. You can pick up. That. So this is now said to the public protector on her own without legal representation. Okay. Then it says on the following day they put an application for postponement. And then here's the important part, the last on paragraph 15. It was submitted that in the postponement application that should the inquiry not be postponed, the proceedings against Mr. Dyantyi would be tainted by procedural unfairness. The university opposed the application. And then it says, that's the proctor, that's I suppose the prosecutor or initiator, whatever. I'm now reading at paragraph 16. Gave no reasons for his rulings. As a consequence, the rulings, neither Ms. Dyantyi nor her representative further participated in the disciplinary proceeding. So let's call that the walkout. So the legal representatives, so if you are granting the postponement, we are not participating any further. Okay? Then the court then says, okay, then it was, what to call it? Accusations of bias, and paragraph 19, it starts with the law. The council of the university approved, and the university applied the disciplinary code under its empowering provisions. Let's call that the directive. Anyway, then it's, let's go to paragraph 22. Whether and when and to what extent an affected person should be permitted or enabled to obtain or retain the services of a particular legal representative has to be determined by a similar balance exercise to the one referred to in the previous paragraph. realistically, I am mindful of the time, but I'm also appreciative of the engagement from the court.
We also do the same.
No, absolutely, I appreciate it. The last thing I want is for the bench that is not interactive. Absolutely, no. I welcome it 1,000 times because it also gives me a chance to cover some of the aspects so that I don't have to do it. Okay.
Because we've got basically 10 minutes left before it's 3 o'clock. And I thought I heard you say that
Mr.
Jamie would also.
Yeah, well, on the basis that the court is not prepared to sit beyond 4, I should assume Mr. Jamie will only start and stop whenever he stops.
Yeah, I'm not going to finish.
Yes, but I'm afraid I can't give an exact. I'll try for 3:30 because I have 2 sections to.
That gives us, that's going to mean that I'm going to have to extend the time for the other people also. They want it. They don't want it today.
Well, if they want.
And I think
There are arguments.
about whether we're going to finish tomorrow.
Yes. I think we will, my lady. Their arguments overlap somewhat. If they insist on having the same time, then their leadership is not correct. Then we might have a problem. Thank you. But I take the message. I'll try and move fast. The court will have time to read this. Let me paraphrase maybe. In the case of Dyantyi, the bottom line was that the court gave an order setting aside the decision convicting the applicant, simply because the postponement was refused, and the legal representatives then left, and the proctor, or whatever that means.
I mean, he was educated.
Yes, proceeded with the matter. That's really the gist of that case.
So you say that aspect is on all fours, the fact that
Absolutely.
the person was denied the postponement and continued without legal representation.
Yes.
Was supposed to continue without legal representation.
Absolutely. And the punchline is on paragraph 31, where it says, in the particular circumstances of this case, a proper balancing of the relevant considerations would have dictated that the inquiry had to be postponed to the date on which counsel for Ms. Dyantyi were available. The failure to do so violated Ms. Dyantyi's right to procedural fairness under PAJA. It follows that the court should have reviewed and set aside the decisions. Courts should follow the results and so on. So the High Court had granted leave to appeal, but it retained the decision, and the SCA set it aside. So this case is on all fours.
But can that be, Mr. Incorporated?
Yes.
In that case, there was a final decision taken. The final decision taken, and the consequence of that final decision was that there was no legal representation.
Yes, but
in this case, we're in things halfway through a process.
yes, well, about the rest, halfway through the process, the immediate issue, it doesn't apply here. And let me explain.
The final decision hasn't been taken.
Yes, of course, the final decision has not been taken, but the decision that we are viewing here has been taken. Right? The decision that we are here about is the non-recusal decision. So I'm saying that that distinction is a distinction about it, because what it would then say, it means knowing that there is binding SCA authority which will notify the proceedings. We must sit there for the next 3 months or whatever it is and waste the taxpayers' money. No, when it's inevitable, as it was said in the Boom case and by Justice Noble in Bennett. If that is what is being demanded of us, then fine. Then we can go through the motions. We don't have to ask any questions. We just wait for the day, then we make that decision, then we come back here. That's not the law. The law says that in particular circumstances, when the point is reached where the violation of the fairness, as they say here, has been reached, then you should come to court. In fact, we could be kicked out of court on the Bennett authority if we came at the end. Because they say, why did you have to waste time?
Bernard is slightly different, isn't it? Bernard, they didn't raise the issue of refusal at all. Quote, and in this instance, in the committee, you raised the issue of refusal.
Yes, but Bernard, the authority of Bernard, my lady, is it's easier to get it from the head. I read it earlier, I'm not going to read it again to save time. Bernard says the following, that a litigant cannot wait until the end of the proceeding, which is the question Justice Savage is putting to me.
Before they raised the issue of refusal in the new facts at Glick, but here your facts are different and you did raise the issue of refusal.
Well, so I'm even in a better position. Firstly, I raised the issue, but I thought the question that was being raised was I'm saying that distinction actually works in my favor, because what we did was to act as what was said in Bernard and in Bungwan case, which is that at the point at which it becomes clearly inevitable or a fair assembly, that's when you should go to court. You can't be expected to wait. And you'll find that in paragraph 89, I won't read it again. No, I'm sorry, yes, Justice.
Just before you move on, you haven't, and I understand that the time constraints, also taken us through in the same Dyantyi, paragraphs 24 to 31.
Yes.
I mean, to 30
24
rather.
to 30. Yes, I wanted to, but after that warning, I jumped to 31.
Just in fairness to you,
yes.
It seems to me that that's the fundamental reasoning for the conclusion.
Absolutely.
Suppose we could read, but if there's anything that you feel that should
yes,
be
thank you very much.
No,
thank you very much, Justice. I really appreciate that. Yes. 24 talks about, it actually refers to the matter case that is, I'm sure is known to this case, to this court. It was therefore, I'm reading the last sentence, it was therefore rightly accepted that legal complexities and potential seriousness of the consequences of an adverse finding entitled Ms. Dyantyi to adequate representation for the duration of the inquiry. Of course, quite right, Justice. In other words, there is a right in complex matters such as this one to legal representation for the duration. So that covers the 13, and it also covers what we're discussing now. That's quite correct. So at no point, remember here we're dealing with Chancellor J in a unanimous decision of and this court, by the way, Department J court, had strongly asserted that the public protector is entitled to full legal representation. And we all know what that means. So there's no point at which we can just continue when she's sitting there on her own. For the duration of the inquiry, and the reference is to another SCA case, Hamata, and then they say that the transcript of the proceedings, number 25, up to then came to 700 pages. That's a joke compared to what we're dealing with here. Here, before we started, the transcript was 11,000 pages. 11,000 before we just the record. So in such circumstances, the role of the instructing attorney is usually more than of an administrative and logistical nature. There was no reason to believe that this was not the position in this matter. Thus, the rulings deprived Ms. Dyantyi of the services of counsel steeped in the matter, exactly on all fours. Moreover, they did so at the crucial stage of the proceedings and so on. And then it says, which is the defense, by the way, here. They said, no, Mr. Sianeho, my instructing attorney, was there, and therefore there was legal representative.
Mr. Pofu, as I understand my reading of this, and perhaps just the number is that, if you could assist me if I've understood it correctly, is that what the ACA is saying is that it depends on the facts. Depends on the particular facts of every case, and depending on those facts, you've got to do in order to assess whether it qualifies in the sense, I think they use the word themselves, exceptional.
Yes.
You've got to weigh up.
Yeah.
The facts is that there referred to in
The number of
23.
pages, the complexity.
So one would need to look at a particular set of facts, but the principle, if I understand you correctly, you are advancing is that it's really fact specific. It depends on the particular circumstances and the weighing up of those circumstances. It's not a what I would call a 6 or mix.
No, it's not. Remember the starting point, okay, maybe let me move. The starting point is that we all accept, I'm sure we all do, I'm sure particularly my learned friends, we all accept that there is no, generally speaking, which is the point you are raising, there's no, even when you have a right to legal representation, there's no right to a particular person. We all know that. Courts always say that somebody comes in and says, oh, my lawyer, this and that, and the court will say, well, across the road there are 200 advocates or whatever, so you can't go and get one. Of course, that we accept. But you are quite right, Justice Glick. What this case says, in no uncertain terms, that right to a particular legal representative must be there when you are dealing with 11,000 pages, counsel that is steeped in the matter, and they are not available, in common cause that they are not available for whatever reason, as I say, maybe one was hit by a car or whatever. And you have 700 pages here, and so on. So I accept that. I'm not quibbling about the right to a particular counsel. It's generally, it's
So that I understood.
yes, no, 100%. Thank you. No, thank you. Thank you for allowing me to make that point. Because that point, by the way, is made in Gedezi, in this court, as which is, you'll find it 244 of volume 1, sorry, of the authorities banded. This court paid Gamble AJ as it then was, excuse me, and Low J was faced with that situation. The accused here not only wanted a particular lawyer, but he said he wanted a Xhosa-speaking lawyer, and the court obliged. And then he then terminated, and then if you go to paragraph 17 at 248, he terminated the mandate of Ms. van der Westhuizen and secured the services of Mr. Bobotyane. So it says this seems to accord with his earlier indication that he wished to be represented by a Xhosa-speaking lawyer. Now, what happened, because of time, I'm not going to read it blow by blow, but you'll see that in that case, from 249, there's a literal transcript of what followed. And the court says the trial is going to run, Mr. Bobotyane. You can then decide what you want to do and how you do not have. This is it. It is not acceptable that the case postponed from July to November, blah, blah, blah. In other words, what they're saying is that the inconvenience of the witnesses, which is not a small matter, and in that case, I think they said 20 witnesses, 20 witnesses who had been inconvenienced in what happened. And so the court said, we're going ahead. And then Mr. Bobotyane tries, like I tried there. Your Worship, in all respect, with due respect, what this is not, it's not open to discussion. This is my order, and you should continue. You must decide. This is at 250. And so it goes like that. Then Mr. Bobotyane says, well, Your Worship, in that event, the situation, Your Worship, then I should withdraw. And then if then the Honorable Court does not excuse me from the record, I've got no choice but to stay on record. But however, no questions that I'll be able to ask the witnesses now. In other words, my mandate is now been terminated. And then another exchange. Your Worship, apologize. When it gets to that, you can get up and say something and things can be sorted out, because it boils down to a threat and that do not take lightly, as the magistrate. And then he says, he's going to leave. Mr. Bobotyane, 251. Why? The reason being, says the court. He says, Your Worship, lack of instructions, Your Worship. And then he says, accused to your advocate now request to be excused. Do you wish to say anything? There's no microphone there, blah, blah. Then the accused says, I cannot defend myself, I do need to have an attorney. Then the magistrate at 252, so you are excused, Mr. Babuchana, because I cannot force a legal representative to stay on record, because it would be, at the end of the day, prejudicial to the accused. Then accused 1 at 252, I'm not prepared, Your Worship. He's now left alone, the lawyer is gone. I'm not prepared, Your Worship, to continue with this trial without an attorney, Your Worship. This is not just this is a murder case, Your Worship, and I'm not prepared to continue with this case. And the court says, unfortunately, it is your negligence and your arrangements, in other words, you are the author of your own misfortune, as they say here, that caused you to be in the position you are in. It's not the court's fault, it's not the prosecutor's fault, it's not Mr. Bobotani's fault. The trial proceeds today. Is over to him. Accused number 1, do you understand the charge? He answers, I said before, Your Worship, that I have nothing, because I cannot continue with this trial without my attorney. I cannot continue with this trial on my own. Then they ask him another thing. I said I'm going to answer nothing, Your Worship. There's nothing I will ask without my attorney. And so it goes. The court, in a nutshell, this one. I'm sorry, Justice.
Sorry, I think really the number is paragraphs
24. 24.
Correct, yes.
Yes, 24.
Really 23, 24,
27.
Just to assist you.
Yes, no, perfect. In fact, to save time, I'll just jump right to 27. At the end of 27, the court says now, the subsequent inability of the attorney to take instructions during the week in which the matter stood down to get the second appellant before the court was due to the attorney's non-availability and was not attributable to any directed tactic on the part of the first appellant. And then the court says, I'm not without sympathy for the court accord not being able to continue the matter, particularly since the principal witness for the state had come from the Eastern Cape, was in the witness protection and had a small child. But in my view, the inconvenience to the court and the witnesses of a short postponement was far outweighed by the prejudice to the first appellant, who was then effectively deprived of the right to legal representation, which is what this is all about. And then the... Yes. Yes, my lady. And one can say that as well. Here, remember, we have reasons given. And the only reason that's really tangible is that, oh, well, the witness. No, they only say.
The prejudice could be cured if any, sometimes cost orders in normal.
Absolutely. Yes, the prejudice that cannot be cured by cost, yes, that's the usual formulation. But the point here that is made by this court was that it's at paragraph 31, which is what Justice Klute is driving me towards, which is the conclusion. The regional magistrate incorrectly ascribed the first appellant's ability to proceed on the 20th of November to his negligence. This was a clear misdirection. I'm of the view that the regional magistrate did not exercise their discretion to grant or refuse the postponement properly. And the decision to refuse the postponement in circumstances amounted to an irregularity in the proceedings, which was sufficient, which was of sufficient magnitude that it could readily be said that the first appellant did not have a fair trial. Remember, that's at the bottom of this case, whether there was a fair proceeding. In the light of the severe prejudice to the first applicant, this court is entitled to intervene. In the circumstances, the conviction and sentence of the first appellant fall to be set aside, and the matter remitted to the regional court for a retrial before a different magistrate. Mr. Akela accepted that this was the correct route to follow in the circumstances. So what the court was saying was two things. One is that this is such a gross irregularity in the denial of the right to legal representation, but that if the matter goes back, it must be remitted to a completely new tribunal, because this person was obviously biased. So, which is what we're arguing here. Now, let me quickly, I won't get into much detail about the following dates, because there's something in the submission that I need to make. As if that was not enough, my ladies. On the 1st and 2nd of November now, Remember, they've said, no, you can't have your postponement till the 7th, which is unfair on its own. Come the 1st and 2nd of November, the inquiry actually sits and they call a witness, a Mr. van der Merwe, on the 1st and 2nd. These were not scheduled dates. The 1st and 2nd. These were dates that were just determined in the air on the 28th.
There was no legal representation to schedule that.
Absolutely. Well, no. Dates are not scheduled with legal representation.
Not scheduled in the back room.
Yeah, no. The dates are scheduled. Were scheduled in the beginning in July. Right? Yes. So these were dates that are not. There's always a program, my lady, which runs like the current one. I think runs up to April or March or whatever. So the dates which are not sitting dates or a week for here because they are in Comm and. Yes. So these were not scheduled dates, number one. But let's even assume they were scheduled dates. The legal representatives are not available for understandable reasons. Nobody is disputing the fact that they have to file papers in the Constitutional Court and what have you. It's common cause. But for whatever reason, quite frankly, how do you then actually conduct the proceedings on the 1st and 2nd? Call a witness. The witness is examined. They ask questions and everything normal. No public protector, no lawyers. What do you call that?
So by that stage, your client also not present on the 1st and 2nd.
No, she came. No.
I thought she was there on the 1st.
Both days.
No, she was always there.
Oh, sorry, I thought
Yes.
you said no public protector. That's why
No.
I'm confused. I thought she was.
No, absolutely not. There is a mistake. Thank you.
No problem.
Yes. No. Remember, because she reports to Parliament, she, as I said, unlike me.
She was only absent on the day she was asked for the last, otherwise she was there.
Yeah. Only the illness. That's only the 13th. No, thank you for that correction, Justice. But anyway, the point is that on the 1st and 2nd, there are no legal representatives. In fact, the public protector was also as good as not being there because, as I remember, if we could play it, she had headphones, but she was there. She actually made a statement. She said, I'm being held hostage here, like a woman who has been abused. Because why am I here? I'm only here because if I go, you're going to say I'm defying Parliament. But I'm just a hostage. She used that word. So it's true that she was literally or physically there, but she was there. And I can't remember the example she made of. It was like a woman in the Ubutwala kind of example. So.
I'm so sorry to interrupt you. So I'm trying to get the chronology
Yes.
here in mind. So she was effectively physically
Against her will.
Effectively did not participate.
Yes, absolutely. Yes, and against her will. Expressly so. She said, I'm here against my will, but there's nothing I can do. I'll just sit. So anyway, this did not deter these people. They went on the 1st, they went on again on the 2nd, absent legal representation. Now, you'll find at 6:42, thank you. 6:42 in the middle of the page. I said, I feel, I'm giving an example saying that to a woman who is abused, just to stay in that relationship, I'm saying I feel like that. I'm not saying you are doing that. That's how I feel. And I'm saying to you, he's saying I'm disingenuous. So I wonder whether that's fine for a member of Parliament to say that in these proceedings. So it's nothing, and I wonder whether you request him to withdraw that and so on. But the point is that is the indication that she was there against her will. Yeah. Now, in which world, my ladies, in which world can it be that proceedings, if I can even call them that would be too generous, can continue over 2 days with a hostage who is unrepresented, and we say that's fine. No, that's fine. You must just grow up. I don't know what. Now, in a situation when the Constitutional Court, no less, has emphatically stated that this person is entitled to full legal representation, in which world can that be all right? And or that the public protector after that must just sit there and carry on for the next few months or whatever, however long it's going to take, and not approach a court of law. Please, let's at the very least put ourselves in the shoes of this person and go back to what my learned friend Mr. Clark was saying. The reasonable litigant in that position, let's say it was you or me or your child or my child or brother, my sister, whatever. What person of any description in South Africa would not have the perception, a reasonable perception, that here I'm just being persecuted, let alone biased? So this is the experience, and I'm indebted to the court. So if you go 13, 27, 28, 1, 2, that is probably the worst. The case of Dyantyi pales into insignificance compared to what I've just described to you. And that, in any event, the case of Dyantyi, which have much nicer effects, is binding on this court. Because the case of Gedezi, at least is a court of this, rather a decision of this court with 2 judges. So at the very least, it can be departed from if it's clearly wrong. But in Gedezi, it was made clear that this was a gross irregularity, this kind of behavior. But in Dyantyi, it was authoritatively decided that this is not something that can be countenanced. So let me run quickly then to something else, while I still have a little bit of time.
The status of the inquiry as we speak is what?
Okay. Thank you, Justice. The status of, well, remember they refused the postponement, which is why we're here. We then said, okay, we are going to bring an application on an urgent basis for the 13th of December. Quickly did papers, and even that we were doing it for convenience because the proceedings were going to stop on the 5th or 6th of December. So we said we don't want to disrupt the proceedings. We'll do it on a date that is not a sitting date. On the 13th, we wrote to the judge president, and everything was set for that. We even threatened that if we can't find a full court, we'll just go to the non-urgent court. Anyway, fast forward, we had discussions with our learned friends, and then we agreed on the current dates because it was the judge president made it clear that was during recess. He would not have judges available and so on. And we had negotiations, then we agreed time frames. I think we wrote a letter to the court around the 12th of December or whatever, and then we agreed on this date. We exchanged diaries and so on.
So, I think what Justice Savage and I was saying here, so as we sit here now, there have been no further proceedings.
Yeah. Oh, I'm sorry. Yes. No. Yes. No. That's the whole point. That's why we're here. We're here. This is urgent court for all intents and purposes. We're here exactly because the proceedings are carrying on. There's an estimated cost of these proceedings. Don't ask me to justify it. But one of the members, Mr. Hendricks, said that the process costs 1 million rand a day, the whole thing. So that's what we were saying. Postpone the thing. Let's go to court. If the court says you can proceed, you proceed. Maybe you lose 2 weeks or whatever it is, but you can't be carrying on and calling witnesses and stuff. So we are doing the up and down. Last week we were here the whole week, had to leave our families and for proceedings that are inevitably tainted with bias and irreversibly so.
When did they stop in December?
On the 6th, thereabouts, my lady, yes.
Resume?
and resumed on the 30th.
Okay.
Yes, that's last week, Monday. And well, the interesting thing is that when it's the members that are not available, there's no problem. So because there's a sauna now, we're not sitting. And next week there's a debate of the president's speech. So, it's all very well. But one day that the public protector says, my legal representatives are not available, then, so we're sitting now next on the 13th, which is next Monday, yes. All this in aid of what? It's just stubbornness, for lack of a better word, of people who are so prejudiced that they can't even allow a process just to go to court. Have the court, if they are acting in the right, the court will say they're acting, it's fine. And at worst, we'll lose a week, but save money or whatever. But what is it in aid of? If it is pure, sheer vindictiveness and inner hatred, prejudice, and bias. Yes, okay. Well. All right. I'll just paraphrase the next. So that takes care of the. We've done the Mileham decision, and then the legal representation, the illness, and what have you. The next issue that I want to talk about, and I'm literally going to spend less than 5 minutes on this, and refer the court to the heads, is issue number, or rather ground number 3, and the non.
Refusal to subpoena.
That's the refusal to call the president. And then remember, my lady, I had said I will sneak into that the witness decisions in general. So what happens here? Again, it goes back to Justice Savage to this question of in-race media, in media's arrest. Because I think I made this point in the morning. If the complaint is that witnesses that should have been called are not called, then surely you can't be expected to wait until the end, because that's just a waste of time. The thing will be fatally flawed anyway. So to cut a long story short, you have 4 witnesses. They fall into 3 separate categories. One is Mr. Ramaphosa, who is, let's put it this way, is in the very same position as far as the charges are concerned. Is in the same position as Mr. Van Loffenberg and Mr. Pillay, because those witnesses were called in relation to court cases in which they featured, where the public protector was criticized by the courts, which form part of the charge sheet. Right? Now, we say to we say, look, there's another charge that deals with the CR-17. The public protector was criticized for
wanting to launch an investigation into the campaign and his remarks allegedly.
Yes, and whether he's the president, he acted as the president.
A change of answer that he allegedly gave.
Yes,
Pardon.
yes. But the nub of the issue was that she had proceeded against him as the president of the country, or deputy president, whereas according to the court, he raised that money as ANC. Absolutely. So that's the nub of the issue. Don't have to bore you with those details. The point is simply that he is in exactly the same position. If Mr. Pillay and Mr. Van Loffenberg were not even actually the primary people being investigated, it was Mr. Godard was being investigated. So if they are relevant in the eyes of the community, then how could Mr. Ramaphosa not be relevant? Well, he also features in the charges in the same way. But that's the complaint.
So there was an inquiry by the public protector's office in relation to Van Loffenberg and Pillay, wasn't there?
No, that's what I'm saying. They were peripheral witnesses. Unlike Mr. Ramaphosa, who's a primary, he's the one who actually took the public protector to court. In the case of Mr. Van Loffenberg and Mr. Pillay, Mr. Van Loffenberg was just, let's call it a witness. The case was actually against Mr. Yehudah. It was the so-called rogue unit. Yes, yeah, those things. Mr. Pillay maybe can be compared to Mr. Ramaphosa because Mr. Pillay, I was involved in that case. Had brought a case about the so-called pension, whether he is. So, in his case, at least you can say. But the point I'm simply making is that in relation to the charges, if anyone is just a neutral person, in relation to the charges, say this one involved Mr. Van Loffenberg, you call him. This one involved Mr. Pillay, this one involved Mr. Ramaphosa, then you don't call him. And what is worse is that there's a legal opinion. They get a legal opinion from their own parliamentary advisors, which says that there's no impediment against calling the president to testify. And they distort it, literally. I mean, there's an MP, Mr. Heron, you'll see from the record, he was horrified. These people are discussing the issue, and then they all say, oh, we agree with the opinion that we don't have to call the president. Until Mr. Heron said, excuse me, which opinion are you agreeing with? The opinion says there's no impediment in calling the president. So,
I apologize for
no problem. So I'm
but
also
just
trying to
so-
rush. I
no,
understand.
but just so that I understand this.
Yes.
Who made the decision not to, I guess, call?
Yes.
I'm going to use that in inverted commas, the president. Was it the chairperson alone, or was it the committee?
It's both. Well, at least it was communicated to us by the chairperson, but we understand that it was the committee. When I refer to Mr. Heron's input, for example, Maledi, that's during deliberations.
I understood that has to be a committee.
Yes, no, that was. In fact, all the non-calling decisions, whether it's even the ones that Mr. Padlander was referring to in relation to Ms. Mazzoni, which, by the way, he was, I'm prepared, I don't know if it's in the papers, but I'm prepared to accept that there was a decision.
Sorry.
Sorry.
So all decisions concerning calling of witnesses, those are decisions taken by the committee.
Yes.
Not by the chairperson alone.
No, not by the. Remember, the chairperson is cited by Lady in two capacities. He's cited as himself, as the biased.
Chairperson section 194 committee.
Yes, but in the actual affidavit, we explain that he's cited in two capacities, as himself as a biased member of the committee or biased chairperson, but he's also cited in any event as he was in all the other as a chairperson, like let's say chairperson of a board or whatever. So he represents the committee, but he's also cited as himself.
So, I can just ask you this thing.
Yes.
Is it enriched? Or is the submission? Because I look quite carefully in the papers and I might have missed it.
Yes.
Is that the chairperson somehow influenced the decision of the committee not to call a recall because of his bias? I'm just trying to understand
No.
the connection, because the committee, we know, is not being accused of bias as a body.
My lady, I understand. It's a function of what I've called clustering these things.
No, thank you.
No. So that's what causes the confusion. The decision, remember, we say, I think some of the papers, I'll deal with it in reply. We say that decision not to call Mr. Ramaphosa, we say it was taken by the person and or the committee, because at that stage it was not clear. When we got the record, it was clear that there were actual deliberations. So but fortunately, we had covered our backs on that. So it doesn't matter whether it's a decision of the chairperson or the committee. It must be set aside, that decision.
But I think my difficulty with that is that if I understand it correctly, the attack is bias.
Yes.
So the disjunct for me, and I may be misunderstanding this, is that I do understand the attacks on the chairperson, let's call it Mr. Dyantyi, his
Yes.
personal capacity, and obviously Mr. Mileham. And I don't see that there's any suggestion that anybody else on the committee has demonstrated bias, and if I also understand it correctly, these decisions are taken, I think, by majority.
Yes, I'll let you know. Yes, you're right there, Madam.
Okay, so
But
that's why I'm losing the little part in my own mind.
no fun. Yes.
That just because he may be cited in a representative capacity in the body of the proceeding we have a day with, how that then somehow makes that less.
Okay.
Mr. Mpoko, may I just add to that? I'm not sure if you noticed the motion at page 1, the one, but it said declaring the first and second respondent's decision.
Yes.
Taken and confirmed on the second.
Yes.
To refuse and or omit to summon, subpoena and or
Yes. Yes. You know, when you read the papers, it will be very clear. But let me just refer you to one part. Paragraph 4. So the first respondent is current chairperson of the Section 194 committee. The committee established in terms of rules of parliament, Mr. Dyantyi, care of the speaker, whatever. He is cited both in his official capacity as such, in other words, to represent the committee, and in his personal capacity as the decision maker in respect of his personal non-recusal decision. So when it comes to his non-recusal decision, he took the decision. But remember, even in relation to the non-recusal decision, that decision he took on the advice of Mr. Jamie, and then he presented it to the committee. So again, it was made twice. It was made by him, but it was also made by the committee. And we are saying both decisions, both the non-recusal, his own non-recusal decision, and the committee's endorsement thereof. In the same way as Mr. Mileham, we attack his decision, Mr. Mileham, not to recuse himself, but more importantly, we attack the committee's endorsement thereof. So there's no doubt, I'm quite confident that when the legal justices read the papers, it will be clear that in every instance, we attack the decision of the primary decision maker as well as the secondary decision. For example, Mr. Dyantyi's decision not to recuse himself, I think, was taken on the 18th of October, and then it was endorsed by the committee subsequently. So I'm quite, because I was concerned about this when we were drafting the pleadings. So I'm quite confident that it's made clear. If there's any confusion further, I'll put it in reply.
I'm sorry, it's not half past. Sorry.
Okay.
It's not half past justices as we order. So very patiently. If my little thing wants to take the rest of the day, the court's prepared a lot of not much I can do about that, but then it is going to kick us out for self-list other than reply tomorrow.
You say you can't start your submissions today?
I can start right now.
Right.
Justice.
Yes, Dr.
But I don't want to unduly. I understand what it's a difficult case. So.
Yes. Thank you, Mr. Jamie. I've been trying to guide you with regard to time precisely because I expected this would happen and the time arrived and you have not completed the submission. Do you want to leave the rest to reply or do you want to soldier on now?
My lady, well, it's only the first time that the chairperson deprives me rights to represent my client. But, I don't mind. Yes, of course it is. I'm in the court's hands. I'm trying.
Time would you have?
Well, the problem is I'm fielding questions which I really, really want. I don't want to discourage questions. But I don't know how many questions the court is asking.
Yes, but assuming there's no further questions, how much time do you still need?
10 minutes?
Right, and then let's work out now how much time, extra time we're going to have to give all the other people. I'm thinking we're looking at easily about 40 minutes extra for the other people.
Yes.
That's fair.
I'm sure
And that may well be that we don't finish. We might just be minutes.
it may, my lady, but also, at least for my sins, I can promise that I'll cut my reply to the bare bones. If it's possible to finish to no.
We don't inspire ourselves from listening to you.
Absolutely. No.
So we don't want you to cut the bones, but you've got to manage what we've been given.
Absolutely. Yeah. No. Let me do this. I'm going to leave this talk. I don't know. Mr. James indicates that he'll start, maybe just give introduction and so on. So then I'll cut to the chase. The issue about the non-calling of witnesses, the significance thereof, is not just your typical Audi problem. It obviously is an Audi problem because you're depriving somebody of legal representation is deprivation of Audi. But it is of the species of Audi which was described in the Dyantyi case and also in the Gedezi case, which attracts the inference of bias. Because somebody who just says, look, I'm going ahead tomorrow, I don't care, whatever. It's not just depriving you literally of the right to legal representation, but it's clearly it's a manifestation of bias. Now, when it comes to this issue of non-calling of witnesses, I made the same, and that's why I'm interested in the debate I was having with Justice Yes, because, and as I say, I'm quite comfortable that the court will find this in both in our hands. It's both. Yeah, particularly the decision of the committee, as I say, to endorse those non-recusal decisions of Mr. Mileham and the chair. And the reason we have a gripe with the committee is what one might call the tyranny of the majoritarianism. Because those decisions are, as we say in the papers, are taken in a knee-jerk process where even when minority parties say, I mean, you remember there's an MP who said to Mr. Dyantyi on the illness thing, what are you doing? How can you deprive a woman and you even demand the nature of the illness and so on? But all that was ignored. Why? Because that person came from a minority party. So the fact that she was right in raising that sharp issue was brushed aside because the committee wants to chop the head of the party. So you'll find all that in the papers. So the committee is certainly a target. So even, let's assume Mr. Dyantyi was the best chairperson ever in the world. We would still be here on the basis that the committee, maybe it would have overruled him. The committee has taken those decisions. Now, the next issue is about utterances. No. The utterances, they speak for themselves. I'll try and save time. You remember we say that that's ground number 8, I think. We say that Mr. Dyantyi had actually made utterances
outside of the committee.
Yes, that
in an interview with a journalist.
No, in Parliament, he had said that she's incompetent.
No, prior to the committee.
Yes, and
but his appointment was not challenged.
His appointment
as chairperson wasn't challenged at the time. Prior when he was appointed.
No. It wasn't challenged as such, except that on the first day, as Malaya my club was a page yes, and among the things that were raised, yes, I'll get the reference in the reply. Among the things that were raised was exactly that. The chairperson had made previous utterances and so on. But this one where he actually utters the word incompetent, came to our attention probably subsequent to the first day. But the point of the matter is that it doesn't matter. Let's assume it was discovered 10 years later. But the point is a litigant in the position of a public protector expected to believe that someone who has called her incompetent, when incompetence is one of the charges, can bring an objective mind to bear on these charges. That's the issue. And my learned friends miss the point because they say, firstly, these utterances were made before. But in Bennett, our heads, no,
You want to refer us to the page 64 of volume 1.
no, because then I have to find the actual passage. Our heads of arguments, I think it's paragraph 8 or so of our heads of arguments.
That is the note.
Yes. All right. I can find it.
You mentioned that on page 42 of your read, and the footnote 40. Which is answered ground 8. Which you don't actually.
Okay, got it. It's all right. I'll refer to it in the slide. But Bennett says that utterances made before the proceedings are a sufficient ground for recusal. So that's I'll make that reference. Let me move away from the utterances. It's clear that if you make such utterances, you are effectively disqualified. Then the last point is the issue of the expansion of the mandate. That's ground 1.
Expansion of the mandate or expansion of the charges?
Of the charges, of the motion, yes. Sorry. The ground 1, again, was raised on day 1 of the proceedings. And I'll paraphrase it like this. Let me make an example that shows the absurdity. After all this rigmarole of the independent panel, the judges, and what have you, going through 11,000 pages, then this is the view of the committee. We say to them on day 1, wait a minute. In fact, it's irony because they want to say, no, this was not the Mazzoni motion, but the parliamentary motion. So we say to them, no, you can't go back to the Mazzoni motion, as you have said, because that motion has now been filtered through the independent panel. And the independent panel has found that some of these charges do not meet the prima facie standard. So surely we're here now to meet the remainder. So I always make this example in this ridiculous fashion. I say, let's assume there are 2 charges against the public protector. One is that she stole somebody's car. The other one is that she beat up an employee at work. The independent panel says, on the theft of the car, there's no prima facie evidence. But on the beating up of the employee, there's prima facie evidence. Then you go to Parliament, and Parliament says, no, we're going to have an inquiry on both. How? Because the whole purpose of having a whole judge of all people going through this whole thing is to ensure that it's like a section 174 in a criminal matter. Is to make sure that it passes the next heading. In fact, it will be better for us when operating courts. Assume that there are 2 charges, and the court says, okay, we discharge you in terms of section 174 on the matter, but you are here for the possession of firearms or whatever. And then the trial just carries on the murder as well. That's inherent prejudice. So we make this clear. They tell us to go and jump in the lake, basically. In other words, we even where there are two, and there's a Pillay, Mr. Pillay's charge. The independent panel specifically said we don't have evidence on this or something like that. With Ms. Baloy, who was even called as a witness, independent panel said there's no prima facie evidence. And so it's articulated, and because of time, I'm not going to be able to deal with it in detail. But these are the types of probably mind-boggling decisions or rulings that we have come here to set aside. Sorry, Justice Kenneth, please. Yeah. The passage I was looking for in Bennett is at paragraph 89 of our head. I won't read it. Yeah. Thank you. Sorry, Justice. 89, yes. That's the one that talks about utterances. On page 34. It says, may arise from conduct of utterances by judicial officer prior to or during the proceedings. Sorry, Justice. No, I was waiting for a question.
So, if I understand the nub of your argument on ground one,
yes,
it's that the ambit of the inquiry is limited to those instances in which independent panel found that there was prima facie evidence.
yes. Well, if you, that's the nub.
That's the nub.
Yes, but to put it in legalese, we're saying that the decision of the committee to expand the mandate, so to speak, you know what I mean? To re-expand the mandate is irrational.
Yes, so that's the second part of your system.
Yes. And we're saying that irrationality amounts, in such blatant circumstances, amounts to a manifestation of bias and the desire to pursue the witch hunt against yes, those are our submissions, and if I may just emphasize that the other issues about cross-examination and the relevance and so on, and we're not abandoning those issues, but we are of the view that if what we have said about all the issues we've said is not good enough, then nothing ever will be, because it's serious enough. Even the one-strike rule applies. Even one of these, whether it was the Mileham decision, whether it was the legal representation, whether it was the postponement, whether it was the utterances, whether it was all these other things, one of them would be sufficient to taint these proceedings with bias, let alone 5, 6, 12, or whatever. Let's go.
Justices, it's difficult to argue against the public protector's case because the case is not coherently or clearly made. It's contradictory, it's inconsistent. In the pleadings, I'm going to take the evidence to what I said that. And in various respects, it's just plainly wrong what is pleaded. It's a matter of law. Also, it ignores the submissions we've heard, ignore basic principles of adversarial litigation and in motion proceedings, especially, and most clearly ignores Plastonetics, i.e. that these cases concern perhaps an early attempt to examine witnesses orally and respond to it. So even where the public protector, where my clients, the chairperson is given.
Mr. Jamie, I do apologize. We do compete with a rather loud air conditioning system, so if you could just speak a bit louder.
I've never been accused of not speaking loud.
I'm sure that you'll relish the shock of being able to shout. You won't, I'm sure.
I'll try to make it louder. I'm sorry. So justices, the point is, in the ordinary consideration of a matter like this, on a motion, obviously, unless the well-known exceptions apply, it's the respondent's version that will accepted. Now, there are a number of examples of this. I'm not going to refer to them all, but that's just one that comes to mind. There's been a complete explanation. Well, there are at least two of the supposed grounds where there's a complete explanation on the chairperson's part as to what the correct facts are. And I'm not going to repeat against my standard against the standard answering of those, but the court would be well aware that apropos bias and reasonable apprehension thereof, the application of those tests take place on the basis of the correct facts, not incorrect or subjectively viewed circular facts. It's the correct facts. And the correct facts in respect to at least two of the grounds of attack. The one being the instruction to Mr. Leon Manuel of the State Attorney to provide the ruling or judgment of the Constitutional Court to a full court of this division while judgment was outstanding. That is attributed to the chairperson. But the chairperson has said in terms he did not provide that judgment to Mr. Manuel. He did not
give instructions to Mr. Manuel.
He did not give instructions to Mr. Manuel. He was unaware of the instruction at the time. Now, that ordinarily, in the instance of a prudent or just reasonable litigant, would be the end of that complaint. Certainly, at the instance of an admitted advocate of this court, who moreover is a Chapter 9 institution, that should have been the end of that complaint. It isn't. That complaint is persisted with before you today. Now, that is not with regards to respect the mark of a responsible litigant. Moreover, I emphasize the admitted advocate. There's a second example. The pleading itself, the filing affidavit, is ambiguous. It doesn't pin the charge, the complaint against Mr. Dyantyi squarely. What it says is, in body 1, and this is with regard to bottom 1 of the pleadings. Sorry, I'm just looking for my note with regard to it's para 129. Yes. If I could ask you to go to para 129, Justices.
What page?
It's at 46 of the filing affidavit. And this is the complaint, 5th round. And it's a sub-category of the 5th round. So I've just dealt with what you found at 127, same page 46. But now at 129, the public protector says the following. As if that were not enough, and on the same day, and then these are the words, the National Assembly. So she doesn't know. This is what she says. The National Assembly and the chairperson issued a media statement celebrating and supporting the order of personal cost against the public protector. Now, insofar as that relates to Mr. Dyantyi, it's obviously meant to bolster the accusation of bias in his part. But as I've just submitted to you, it's not made in unambiguous terms because the author or the drafter of this paragraph doesn't know who it was. So they say it's the National Assembly and all the chairpersons. Now, once again, Mr. Dyantyi gives a complete answer under it. He says it was not me. My business, my job is not to issue media statements. It was not issued. It was issued by politics. And the media statement, it is somewhere in this papers. I'll give you a reference there so Julius will well addressing it. Makes it clear that it's a media statement of the National Assembly. Mr. Dyantyi's name does not appear in government law. Despite that accusation against Mr. Dyantyi is persistent. So today, before you, it's one of the grounds in the heads of argument. not being withdrawn. That is the nature of the attack that we're going to deal with. And it makes it extremely difficult with respect to deal with it and break it down into a coherent attack, which you can.
Are those the only two
No.
alleged facts of this representation movement?
No, they're not.
I think the addendum springs to mind as something the chair also said was not actually proceeded.
What the amended directives?
Yeah, amended addendum to the directive.
Well, you will recall, as I understand it, and again, I'm not as steep in that as Mr. Fulford, but they say, well, even if you have, it seems they do accept that the directives would amend, the purported amended directives were never brought into effect.
They said
But
we were not consulted.
they say because they allegedly were not consulted, that itself, it doesn't matter whether it was brought into effect or not. The mere attempt to do so shows bias. But they don't deny that the amended directives never came into effect. That's as I understand it.
My understanding correct, the chairperson's position, the principal position is that they were consulted and as a result, some of the amendments, the proposed amendments
Your leadership is entirely correct. Some aspects.
that's supposed to be another misrepresentation, but I'm asking you how you make notes of all the alleged misrepresentations.
Just as we've dealt with, we've dealt with in our heads, I will, if I have time, and I'm brave on it, elaborate on it. But those are the two that just sprang to mind, and I thought I wanted to mention up front. They're two particularly egregious examples. I undertake a war overnight. Work on a complete list of I only allow less than 10 minutes an hour. So if I could perhaps just pick up and use the remaining time to considerations. I've referred to the fact that it's difficult to deal with the case in the way it's being cleaned and presented. And can I explain that? So, one of the questions for Justice Savage, she pointed out in print to the notice of motion. And this goes to, so the submissions I'm going to make now go to who is being attacked and who is being accused of bias. That's a question both I think Justice Savage and Justice Glick raised. In fact, the point of fact is, it's the scattered down approach has been done. And the finding out that it goes so far in one paragraph as to say it actually doesn't matter which it is. It's still bias. But with the greatest of respect, any case in our courts is addressed and dealt with by those who oppose them, whose conduct is being challenged based on what's been pleaded. As the court knows, the affidavits are back here. So let's.
Mr. Jeremy, is that not clear from the notice of motion that what is sought of this court, apart from issuing documents urgently received from the court, can be and
It's very.
is that declaring the first and second respondent's decision to dismiss the refusal application, the action taken on the 17th of October, and then taken on the 5th of October to dismiss itself, and then taken on the 17th. That setting aside those decisions, that's essentially the relief that's sought.
It's not essentially relief. It isn't.
That is the relief that's sought this application.
No, that is the starting point. So
That's the starting point.
yes, thank you for doing the business. So if we look at page 1 of the record, paragraph 2, declaring first and second respondents' decisions. Now, I thought those are the chairperson. I learned when it's quite correct, he cited in dual capacity as chair and his personal capacity. It's the chairperson / Mr. Dyantyi and the second respondent, Mr. Mileham. Those are the two persons targeted in paragraph 2, declaring their decisions as listed here under the subparagraphs to be declaring the first and second, looking for, yes, there's some words missing in 2-1, but anyway. Declaring the decision to dismiss the recusal application. So we know those two decisions were taken by them, respectively in respect of their individual applications. My good friend submitted this afternoon that the committee, as distinct from Mr. Dyantyi, took a separate decision apropos, if I understood correctly, if I didn't, I apologize. Certainly made a submission in respect of the chair. I don't know whether he also made a submission in respect of Mr. Mileham, that the committee decided apropos Mr. Mileham.
He said the committee decided
accept he does. We've been analytical with that, but my understanding of the papers, one of my juniors pointed out that he's reading the papers, there does not appear to be a discrete decision of the committee apropos of either recusal application. So, contrary to what Mr. Concord submitted, there doesn't appear to be. But even if there is, the point to make, as Justice Savage has just pointed out, if there are such discrete decisions by the committee in respect of the two recusal applications, they're not being attacked in this notice of motion. It's only the decision of the first and second that is being attacked.
One cannot expand the notice of motion in the final
Yes.
the final that is support the notice of motion. You can't expand and leave the seat in the
And to the extent that we posture that might be, well, he is being cited, the chair in both capacities, and thus, by implication, the first respondent also is the committee. I'm not entirely sure that is correct as a matter of law, but the fact of the matter is we do not read the filing affidavit as pleading a discrete decision by the committee in respect of either Mr. Dyantyi's recusal and certainly not in respect of Mr. Mileham. To carry on the relief that we need, the first 2.1 is the recusal. In 2.2 is the decision on 22nd October to dismiss the adjournment application. Now, this has been attributed to first and second respondents, but there isn't a little suggestion in these papers that Mr. Mileham had anything to do as a decision maker in respect of the sectors. So that relief, apropos Mr. Mileham, doesn't make sense. Not understood. But the same applies with respect to the chair. The chair did not make the decision to dismiss the adjournment application. I'm going to take you to the filing affidavit in that regard in a moment. The same applies with 2.3, the decision of 17 October to refuse and omit to summons, subpoena, and recall witnesses. Those decisions were not taken either by the chair or by Mr. Mileham. That is acknowledged in the filing affidavit. So the notice of motion is inconsistent and contradicts the filing affidavit. The last aspect of the notice of motion I want to address before moving on to the filing affidavit is paragraph 4.4.
Mr. Jamie, I think perhaps another way to consider it is to assess whether the evidence contained in the founding affidavit supports the relief.
Sort of in the notice of motion.
It's two sides of the same
I was about to say it's two sides.
But in fairness, I think that's possibly, particularly given the case that the respondents have been called upon to meet, they have to deal with the case that's laid out in the final page.
The evidence, I'm going to get.
The risk of staging and absolutely obvious thing, I don't know, we need to sound patronizing, this is the wrong day, but I mean, really, it's assessing whether what is contained in the following affidavit and the following papers supports a specific relief that's sought in the notice of motion. And then to balance that against personal
I think the notice of motion must be read, obviously together with that, and where they are not in sync, then the applicant has a problem. Because the relief they seek, well, sorry, then we're on the same page. I'm being confused. This is that and that. The last aspect of the notice of motion I want to just refer to is 4.4. That's part of the substitution relief that is sought. And there is a rather oddly formulated, and we say egregiously, in egregious ignorance of separation of powers doctrine. And that is an order that the committee proceedings will only take place after its composition has been duly corrected and or confirmed by this honourable court. Now, I've gone through these papers, the filing and supplementary, I think quite carefully. There is no elaboration as to what that means and what they want. But they seek an order. And that is going to stop. And I'm going to get tomorrow to one of the principal parts of our relief, which was to place this application in its proper constitutional context and to explain why this application should be regarded as a non-starter. But I'm not doing that now, so I'll come to that tomorrow. But the point at the moment that I just want to make is that order, if it were to be granted, would seriously trench on the separation of powers. It gives the court the power to stop this committee carrying out its constitutional obligations until in some undefined way, not explained in the affidavit, the court is satisfied and has confirmed that the composition is correct. It's not. We say it's legally unenforceable and shouldn't go. Can I now ask the court to go to, and I said I was going to take you to why we submit there's fundamental contradiction, and can I immediately take the court to certificates.
And the method stands down until tomorrow.
Oh yeah, we need this for tomorrow. Please. The book. Oh yes. No, we'll make a plan. We'll bring it tomorrow.
Together with the references.
And references that we all judge. But yes, okay. No, but definitely. Thank you. Do you want to say yeah.
So what are we doing tomorrow? Okay.
Yeah.